Welcome back. This is episode number 10 of the Inland Empire Workers' Compensation Lawyer live stream podcast. My name is attorney Alexander Napolin. I'm here with attorney George Abuado. We're your hosts every Sunday at 3 o'clock on this channel discussing workers' compensation and employment rights in California. If you work in California, you should subscribe to our channel and hit the notification bell so you don't miss out on these important weekly discussions about your legal rights. This is episode number 10 on how long injured workers have to file their case at the Workers' Compensation Court after they've been injured at work. So let's get right into it. The first thing we need to discuss is how long does someone have after they've been injured at work to file a case? What's the general rule?
So generally, the rule is that you have 1 year from the date of injury to file your workers' compensation claim. Now, this 1 year is from the date of injury. So you have to see when the accident occurred. However, what if it's not an accident? What if it's what we've already discussed, a cumulative trauma? There was onset of the injury throughout a certain amount of time. When would the statute of limitations be for that, Alex?
So yeah, there's a lot of nuances to this topic. It's not so clear that you just have an injury and then you have 1 year from that date. Right. But if you do have just one injury, like you broke your arm or you fell off of a ladder or you were involved in an automobile accident, that's a specific injury. You have 1 year from the date of the incident to file a claim at the Workers' Compensation Appeals Board. But what's the date of incident for these other types of claims that you mentioned, cumulative trauma claims, which we have discussed in episode number 4 of the Inland Empire Workers' Compensation Lawyer live stream podcast. Go ahead and check out the description below for a link to that on the different types of injuries you can have. This is a repetitive work type of injury. If you've been injured and you're wondering when did my date start, you need to speak with a lawyer. This is a general discussion that we're having. It's going to help you understand the different issues that you face and how to have a better discussion with an attorney. And if you have been injured and you're looking for a lawyer, call the injury hotline at the Inland Empire Workers' Compensation Lawyer live stream podcast at 844-984-8414. So this cumulative trauma injury, George, it doesn't have this specific date that it's tied to. So how do we, as workers' compensation lawyers, find this date? And when does the clock start to tick on these type of repetitive claims? If you just keep on working and you know that you've been injured, but you never have a day that you miss and you're working your normal duties, it may be that the statute of limitations has not yet run. Maybe you still have the time, even though you have been getting hurt at work and you've just continually worked there. Labor Code 5412 states that you have to have disability plus knowledge, or within the exercise of reasonable diligence, should have had knowledge that you have a disability related to industrial injury. So how long do you have? You have 1 year from the specific date, and then you have these cumulative traumas, which is kind of like a different date of injury. It's a floating date. It's highly sensitive to facts. So it's not so easy as the specific injury. That's why you need to have a lawyer look at your case. That's why if you're an injured worker, you need to call the injury hotline, because we're discussing here the time limit that you have to file these claims. It's important for you to be aware. You have a time limit. It's important for you to know what that is. It's important for you to go protect yourself. It's not going to be that the day before you're going to be able to go to a lawyer and protect yourself. You're going to have to call the lawyer. You're going to have to describe the situation. Now, let's talk about statute of limitations defenses and how weak they are. I mean, I've never had an employer or a carrier successfully argue a statute of limitations defense. And even when I thought that the carrier had a strong or somewhat plausible statute of limitations defense, they paid anyway. Right. So I don't really find it to be super important other than, don't risk it.
What are some things that might extend the statute of limitations past a year, Alex?
Yeah, that's important because a lot of times there are situations, there are laws in the labor code that protect employees from abuse situations by employers, like, for example, not giving the employee who's injured the claim form. Basically, if you're injured at work, your employer is supposed to give you a claim form. And then that claim form, you're supposed to fill that out. Your employer is supposed to fill that out, and you're supposed to transmit that. The employer is supposed to transmit the claim form to the insurance carrier, who's then to extend workers' compensation benefits. But if that's not happening and the employer doesn't give it to you, then the statute of limitations does not start running until the employer gives you the claim form. That's what determines pretty much everything, is when that claim form starts. And if the employer doesn't do the appropriate thing and provide the form, it may be that your statute of limitations period has not started running.
If you're a minor and you injure yourself, the statute of limitation doesn't begin to run till you surpass the age of 18. Till you turn 18, now the statute is running, and now you have a year to file your claim. So if you get hurt when you're 16 and you don't file a claim, you're still okay. When you turn 18, that will be the time when the statute of limitation starts running. So in essence, in that situation, you technically have 3 years to file a claim.
There are situations that you might be experiencing that we are not discussing here. Again, that's the injury hotline, 844-984-8414, or a direct message to our social or to our offices. So if you need legal advice, you need to speak with a lawyer. These are highly fact-specific and driven situations. And oftentimes the statute of limitations, because of the law of liberal construction, they don't apply. And a good lawyer can fight through it.
There's also different statute of limitations that have to do with workers' compensation that we have not spoken about yet, but that could very greatly affect you, such as if you do sign a stipulation with a request for award, which we will discuss. This is where you still get future medical care, and you sign it, and you feel that you're worsening after a year or 2 years, then you are able to file for what's called new and further. So you do have a statute of limitations there. It's 5 years from the date of injury. So if you sign a stipulation with a request for award and it's only been 2 years from the date of injury, you still have 3 years after that to file a new and further claim, reopen your claim, and see if you can get further medical treatment and possibly some more permanent disability.
That's a good point. The 5-year statute for reopening a claim.
Right.
So if you're out there and you have a stipulation and the award is in place and you want to reopen it, maybe because you want to also negotiate a settlement, maybe a lump sum settlement. We discussed that on episode number 9. You might have additional years to do it.
During that lump sum, it's nice because if you do want to negotiate a lump sum after you reopen your claim, it could be that you actually have additional permanent disability, which will up the value of your claim, and you might even have even more future medical. I've seen instances where the first time the claim was closed through stipulations with a request for award, there was no possible surgery in the future medical. There was no possible 10 times a year seeing the doctor, physical therapy. But now that the injury has worsened and you reopened your claim and a doctor saw you again and gave you that extra permanent disability, extra future medical care with possible surgeries, now your claim has a lot more value. And if you chose to choose to close it out at that time, you could get a lot more money in that lump sum settlement like we discussed in the prior episode.
Yeah, so if you're out there and you're hurt, you have one of these stipulated awards, you're looking through your drawers and you're going, oh, I have a stipulation and award, but I feel like I'm surgical now. You need to call the injury hotline. You need to call the workers' compensation lawyer, i.e. right here, 844-984-8414. I'm attorney Alexander Napolin. I'm here with attorney George Abuado. We're your hosts. We're live every Sunday at 3 o'clock on this channel discussing new topics in employment law, workers' compensation law. That's it for this week. Until next week at 3 o'clock,